It's an honour to be asked to contribute to the discussion this evening, which is such an interesting subject, and congratulations to all of those who have contributed to the articles. I've dipped in and out of a few of them and seen the topics, and it's a complete smorgasbord of interesting legal thought, which will be useful in years to come, I'm sure. The topic for discussion this evening leads in particular, as we've heard, to Professor Sourdin's interesting article, and anything entitled Judge versus Robot immediately attracts attention, and alarming attention when you're in my position. After reading the article, and when I'd stopped hyperventilating, I realised that there are perhaps more opportunities than threats tied up in the concept. But in this context, I should make a confession. After watching movies like Ex Machina, Blade Runner, of course the timeless Terminator quadrilogy, there's a sci-fi quality to the words artificial intelligence that, at least as I understand it, is not warranted just at the moment. I perhaps feel more comfortable with considering artificial intelligence in the context as a reference to automated tools and software that are capable of advanced functions. But I don't understand us to be at the point of general artificial intelligence, and at least for the present, Arnold Schwarzenegger is not going to burst into my courtroom and take over. With that in mind, it seems that for the present we can regard automated tools and software with less of an existential concern than a desire to use them for good. In this regard, I set aside the doomsday concerns that the philosopher Nick Bostrom has advanced along the lines that when we finally do get to a point of true singularity or general artificial intelligence, humans have no alternatives but either to become livestock or offer themselves up as pets. It seems that that's the best that Mr. Bostrom can offer. His most pessimistic scenario is that artificial intelligence is likely to be an extinction event for all humans. But moving along to a more cheerful note, I'd like to point to a couple of issues that may be worth considering in the context of Judge AI, which is how Professor Sourdin refers to it. I should start by referring to judgments. That at least is something I know a bit about. Who are they written for, and what purpose do they serve? I'd like to say that I write judgments for law students, knowing that they'll be poring over every interrobang, emoji, quirky catchword and dry pun that I slip into the judgment. But alas, that is a limited role, and emojis are generally frowned upon anyway. First, I write for the losers, because it is important to explain to them why they lost. When you think about it, the judicial branch of government is the weakest of them all. We have no police or standing army. The authority that leads society to accept the rule of the umpire in a legal case is largely reason. It is the ability to explain to the multinational who's just been ordered to pay $10 million to a person who's been injured on its ship, or the father who's been deprived of custody of his child, or the politician who's just lost her libel case, why he or she has lost. The explanation is important, because it puts the decision into a framework of rules that have been set down in advance, are often the result of legislation, and are based on the application of those rules to enable the result to be predictable. Those factors provide a measure of not only legal but also moral authority for the quelling of disputes. Next, I write judgments for the appellate courts so that they can perceive how it is that I came to muck up the decision and correct it. Losers don't inevitably appeal, but quite often they do, and it's important for the appellate courts to be able to scrutinise and critically evaluate mistakes made. I must say that it is also a comfort to know that a decision that I make will be the subject of review, and if found to be correct, as galling as that may be, fix up any errors. A third reason why it's important to give an explanation for the result may be demonstrated by reference to administrative law, where the court sits in an adjudicative role over the decisions of the executive. In that context, the decision not only identifies the winner or loser, but also provides an educational function for the executive, so that future decisions may not fall into the same error. A fourth reason is to explain any developments in the law that have come about as a result of considering how many opportunities of the particular case on hand. It always surprises me and did surprise me when I was a barrister, how many opportunities there are to step out into virgin territory where no lawyer has pushed a judge to go before. No doubt that's because the rich complexity of life throws out factual situations to which previously decided cases have no direct application. Ben Kremer will no doubt tell you in a little bit about barristerial creativity. Most barristers confronted by difficult cases go out of their way to explain to you that as a judge you have the good fortune to be considering the legal proposition advanced by them for the very first time, and that previous authority will be of no assistance. Occasionally they're even correct about that. And so it is that as a judge, whether on appeal or at first instance, one must consider the development of the law from wherever it rested before the case and explain how the development took place. It's perhaps worthwhile to reflect on these points in the context of Judge AI and the use of automated tools. Professor Sourdin incisively refers to the distinction made by Professor John Searle many years ago between syntax and semantics in the context of computers. The fact is that computers receive stimulus, process it, and produce results based on inputs and rules. The rules that lead to the processing involve binary decisions concerning the recognition of symbols. That may involve the production of the correct answer to a particular question, but it does not involve understanding on the part of the computer, at least in the sense that you and I understand things. In essence, the computer responds to symbols. It doesn't understand them. In this context, one first issue, perhaps for consideration, is how Judge AI, or Judge Schwarzenegger, can explain the reasoning that yields a result in a way that carries the relevant legal and moral authority for society to accept it. How does a computer that processes software driven by algorithms to interrogate data explain how it is that the loser lost? I don't just mean by setting out a decision tree, but by explaining the nature of the decision. A related issue concerns the development of the law, such as when a new set of facts arises to which no previous decision can be applied and a principle or general concept has to be applied. As I understand it, one aspect of the advancing progress of automated software tools is the ability to use computers that interrogate databases as a means of either predicting decisions of judges or replacing judges with the predictions of the result. But such a process necessarily only involves looking backwards to past decisions rather than forwards. As Professor Sourdin says, machine learning allows computer programs to learn complex tasks through experience rather than through handcrafted computer functions. Machine learning techniques are only useful where analysed information is similar to new information presented to the AI. A consequence of the decisions being made on the basis of past experience is that they tend to entrench past practices, and even past prejudices. If they're used predictively, they're unable to accommodate changing societal norms or new situations that do not draw on past experience. I can understand the value to practitioners in being able to try to predict the results of an outcome of a case based on the interrogation of vast database of previous decisions. But it's because of this intrinsic difficulty of backwards looking rather than forwards looking that there's a danger that if such predictions are used as the basis for decision making, then the law will stagnate. In 200 years' time, it would be a shame if Judge Schwarzenegger were crystallised in legal thought in Trump's America. Perhaps the development of predictive databases to assist in decision making may well be impeded by an absence of sufficient sample size in order to be at all meaningful. For instance, I understand that in the United States there's a search tool called Lex Machina that's used to predict the outcomes of patent cases and also the damages to which a successful patentee might be entitled at the conclusion of the case. In Australia, that approach couldn't succeed simply because the sample size of decided cases on the question of damages is too small. I draw comfort from that for obvious reasons. Another aspect of judicial work involves not only deciding the cases but also chaperoning them through from commencement until the conduct of the hearings. Although in Western society we long ago ceased to determine outcomes of dispute by two people fighting each other, or trial by ordeal, or any of that, court-adjudicated decisions have been found to be far more civilised as a way of resolving disputes. But even so, in modern litigation, the parties are typically heavily invested in the outcome and bitterly opposed to the other side to the dispute. It may not seem too exciting looking from the outside in at a piece of civil litigation where two dry as dust arguments are advanced politely by well-spoken barristers. But in reality, the tension in a courtroom at the beginning of a trial is almost always palpable. One role of the judge is to ensure that the parties get to trial in a way that is fair to both, and that the rules of engagement are maintained so that each party has the opportunity to present its case. All the arguments are presented fairly, and there's natural justice. That necessarily involves handling the individual's concerns, including witnesses in the stressful position of being cross-examined, and parties who can be in extreme emotional states, to make sure they're treated with dignity, courtesy, and in a manner that is fair to everyone. Movements to utilise technology so that court hearings are avoided, disputes are adjudicated online, and potentially so that witnesses do not need to give evidence, will be productive of greater speed and potentially greater efficiency, but care must be taken to ensure that the human aspects of dispute resolution are not overlooked. A lot of the moral authority, I suspect, that comes from the current system of justice is that people are entitled to have their day in court, that their day in court is public, and that they can see justice being done as well as understand that it's being done. To go too online, to have too many disputes decided within a black box of algorithmic solution may be problematic in terms of civic respect for the institutions. Besides, would it not be a little sad if the theatrical component of trials were to disappear and the only active role in judicial decision-making be undertaken by software engineers whose task is to program the AI? Before I pass on to other panellists who will speak in a far more coherent and knowledgeable way about these matters, I wish to finish on a more positive note. The digital age has led to faster and more efficient outcomes for people in many areas. Books like the Susskind's The Future of Professions rightly emphasise that the speed of transactions and commodification of information — is commodification a word actually? Anyway, that's what they said — of information will mean that the public will not anymore wait around for the quill and ink slowly to be moved to provide legal advice or dispense justice. Consumers of legal services increasingly demand greater access to justice where it is too expensive and greater speed of justice where it is too slow. And of course, what is slow is something which is speeding up even as we talk. This is referred generally to as the democratisation of justice, but as with any other populist movements, it needs to be understood and considered with some caution. The digital age has led to deprivation and reduction in privacy that people have, and one would be concerned that in the process of speeding up decision-making and in mechanising processes, the real benefits of the system of justice may somehow be lost, and that is those human elements to which I've referred. But nevertheless, technological tools can certainly be used to assist in the process of justice. Many advantages we've seen so far, including those concerning discovery and other automatic means, such as looking up cases on Jade and the like, are of huge advantage. So long as it makes the administration of justice quicker, cheaper and better, then it should be embraced. It may have the spin-off benefit that all of us can spend more time at the beach during the summer. Thank you.
Before I begin, I'd like to add my congratulations to everyone involved in producing the issue. I know from bitter experience just how much work's involved in it, so well done. There are three interesting aspects in which technology, Professor Sourdin has nominated technology interfacing with trials and in particularly with judging. And the first two of them, which are supportive and replacement roles, are already well underway. And they're the ones where there are technological aids or processes that either supplement or assist or make much quicker and more efficient tasks or processes that are already being done and have been done in some cases for hundreds of years. I don't propose to talk too much about them other than to note that they are at the moment very big topics. One that comes up very frequently in all sorts of panels and events that I go to is discovery review, and the associated one for those people crazy enough to do corporate work, which is due diligence. And I should say, having seen a video probably means I can't tell any of the good jokes, so I'll have to tell everyone those afterwards. Most of you are probably going to be lucky enough to enter into the profession at a time when the really hard hack work of having to look through, in some cases, hundreds of boxes of documents and thousands to hundreds of thousands of pages is not going to have to be done by that much human agency. And that is something that at the moment there are lots of smart people working on ways to commodify, and I think that might be a word because there's no noun that cannot be verbed and no verb that cannot be nouned. But lots and lots of law firms are realising that the days of putting hundreds of paralegals and junior solicitors onto tasks such as reviewing documents are over, that can be done by electronic means, and then they can be put through after that level of filtering to people for the first layer of review. There is one aspect to that which I don't think has been thought about as much, which is there is an element of lateral thinking or left field thinking that you always have to do if you're doing a job on discovery review or due diligence properly. And that is connecting things that are not literally on their face necessarily what you're looking for, but still go to advance your case or to give information about the contract or the business that you're doing the corporate deal about. And a paradigm, probably apocryphal example, is of someone doing discovery in an American antitrust case where acting for, I think it was the SEC, trying to make a case against the companies that they'd conspired to limit competition by getting together, but couldn't prove any aspects of it because they couldn't prove any meeting of the minds. And when looking through the various boxes, going through pages and pages of anodyne material, one of them picked up a folder and a matchbook fell out. And the matchbook was of a motel. And the motel, when they looked into it, was in the middle of nowhere. And that was, when they checked into all the records, where all of these people had gone and met quietly, under cover of night, in some cases using false names, to actually have the meeting, to be able to set the prices and do the things that they weren't supposed to do. Now, one would have to actually work out how you'd enter a matchbook into discovery software, and also whether or not, if it was entered and it appears as a little sort of picture in the middle of your screen, whether anyone would actually think of that, certainly whether an algorithm could be programmed to capture it. It would seem to me that that would be sort of discarded as being irrelevant without having an obvious connection on its face. But in fact, at least if the story is true, that was the key to proving how the whole thing actually started and led to the case getting settled. And the relevance of that anecdote is one of the things that you don't know when you delegate things to machines is what you don't know. In other words, it's the unknown unknowns. What is it that might have been picked up by people that won't be picked up by a machine? Now, in reality, I think you'll probably find that that's going to be outweighed by the things that people would have missed because of boredom or just an inability to process the amount of data that a machine or an algorithm will be able to pick up. But there always has to be some kind of trade-off when these things are being, in effect, replaced one process with another. Another thing that Professor Sourdin's talked about, which is happening quite a lot now, is virtual courts. And for example, there's a new Supreme Court General Equity Practice Note number 14, which is its usual scintillating reading for those that want to read it. It actually makes, I think it's one of the paragraphs down the end, if you don't read it, you don't see it. You now need to do your general equity matters in the virtual courtroom unless you actually have to take them to be heard in person in court. And it's phrased as being, you need to make a request to the registrar to be dealt with in open court on the basis that the matter is not suitable to be dealt with using the online court. So in other words, not just a presumptive pushing into the virtual process, but to get out of it, you have to have a good reason and convince a judge, in that case the registrar, why you're allowed to do it. But beyond that, I mean, everyone knows lawyers are fairly good adherents to and proponents of new technology. And if you go on, and I have to keep this relevant to my audience, I'm told, if you go on to the Oslo subreddit, you'll see a question a couple of months ago that sort of said, why is it that I see every second barrister holding an iPad? And the top answer, but it was only about 15 votes at the time, probably not too much more, is they took it from a solicitor and just haven't returned it yet. Now, in fact, I should say, in defence of those that I sort of work with, that they actually are reasonably good, especially the younger ones, at getting into the technology and the technological way of doing things. But it is something that I think the profession as a whole, including solicitors, is doing well at. And with that in mind, I'll try to tackle the more difficult, which is the third set of technology, which is the judge AI. Now, I love the idea of judge versus robot. I sort of would have thought you put them in a room and give them a blaster each and sort of take cover, and it makes my job easier at the end of it. But I think from my perspective, which is a weird one, I think you can find a couple of points that are worth thinking about and considering a bit further. And the first, which is really probably a topic that deserves its own sort of entire symposium to talk about, is I think there is still a disconnect between how lawyers understand technology and how technologists understand or try to understand law. Because when you come to look at how anything works at the technological level, the devil is always in the detail. You can't just say something is an algorithm. You can't just say something is a process. You can't just say something is a program. If you start using words like intelligence, a non-technological person will have an immediate fuzzy mental image of what that means, which is often going to be very imprecise and maybe incorrect. And as Justice Hayne would have said, a lot of baggage needs to be unpacked about what these terms mean, and I think you'll find that there are aspects of it that are going to be implementation specific. That is, a particular way of doing something is going to yield different types of results in a different entity from another technological way of doing it, and the two will operate differently, and you'll have to start taking account of how these things actually work down at the level of the software, and you can't just talk about it in the abstract as being a thing, because that I don't think is the way it works in real life. And of course that means you need people who have got or are conversant with both technology and law, and sadly there are relatively few of those people, and anyone that is in the position to try to actually bridge those and work together is in a privileged, fortunate position and should pursue it, because law really needs people that understand technology, and I think those who are programming technology for law do need people who understand law. I think the second takeaway point is probably this. When I sit back and think about what's my role as a barrister, people always say, those that are worth listening to always say, that the role of a barrister is to persuade. Advocacy is persuasion. You're trying to persuade a judge to reach the outcome that is favourable or most favourable to your client, and persuade them against reaching a result that's adverse. And then you think about what that involves. How is it like that? Why is it like that? And I think caught up in that, and this is where I'm going to go between trying to distill things in a way which I think is descriptive, and then try to get involved in the very dangerous business of prediction. Judging requires more than, I think, simply analysing data and simply processing what a programmer would recognise as being input and producing output. And Justice Burley touched on a few of these points, and I think some of them are extremely important. And possibly the most important aspect of judging, I think, is compassion and empathy. Because when you are involved in litigation, you see people at their worst and their most stressed. You've got people whose everything is on their line. If they lose this, they're going to be wiped out, made bankrupt, lose access to their children, lose their home, lose their possessions, get deported, go to jail. There is an element of having to deal with people and be able to soften the blow is probably too harsh a way to say it, but make them feel that they're being listened to, make them feel that they've had their chance to say what they need to say and what they want to say, and that you must leave them feeling that justice has been done and seen to be done. There's, I think, a real danger in a reductive approach where you end up potentially with a situation where someone turns up seeking something from a court and gets the result, computer says no. And it's probably a reference a bit too old for most of you in this room, but I'll move on. But I think that captures an aspect which I think means, if you boil it down differently, judging involves emotion, and there are human aspects that I think are necessary that I think would be very hard to replicate in any sort of automated process. And I think, going from now description into prediction, I think that will not ever really be truly captured in any kind of electronic device. I don't think it can be done in hardware. I think it needs wetware. It may be possible to program something 100 years from now, or to be able to produce wetware or equivalent computing power that actually enables a decision maker to feel emotion and to empathise and to display the kind of characteristics you need to have in a judge. But I think unless and until that can be done, you're never going to go beyond an AI as being a co-judge, or I think as a cobot is a good term in the article. Locked up in that, I think, as well, is the idea that a lot of judging involves making judgment calls about what is reasonable, what is fair. So some of these can be turned into potentially weighing up exercises where you can weigh up, well, 4 years was considered too long in the past, 2 years was considered not long enough, what does 3 years do? And it becomes an exercise in data science. But when you start looking at decisions, for example, on late cheese in equity, you find that things that are easily measurable and easily quantifiable, like time, usually give way to other factors like reliance or unfairness or detriment. And that they're the sorts of things that tend to turn those decisions so that cases where someone is 4 years late but has a very good reason for not having done something are allowed to get out of the consequences, whereas someone who's only perhaps a year late but doesn't have any good reason suffers those consequences. And I think the second reason that it's going to be very, very hard to go beyond something that's just an assistant is that those things can't, at least as far as I'm aware, be turned into some kind of thing that can be measured or quantified or worked upon by any sort of algorithm I'm aware of. Because I don't think it's possible truly down at the core of it to code reasonableness. And I know it's sort of very untrendy and probably not the right thing to do, but as soon as I heard about the topic, I was reminded of something I wrote years ago. In an old article where buried down in a footnote I put something to try and have a jab at someone I was having an intellectual debate with, which I'm sure all the law review people here know all about. And this one, funnily enough, didn't get taken out. But I sort of said at the time, and I think it's still right, that the essence of judgment is that there is some element of normative choice, though constrained and structured. Were it otherwise, computers could and would be better judges than humans. I think I said at the time I didn't really have any practical experience, but I'd still stand by it at the moment, which is not everything that can be measured matters, and not everything that matters can be measured. Now, it's not my quote, but I think it's very apt in this area. And I think the final point that I've got, which I think is the third takeaway, looking at this from the point of view of someone who's sort of in the middle of it all, but not actually having to do the judging, is there are aspects of courtroom, I wouldn't say courtroom behaviour, but things that go on during a trial that are also very, very hard to capture. And they're very hard to capture even in the current system. So, for example, when someone gives evidence that is so implausible that everyone in the courtroom laughs, and it's obvious that it's not being accepted, but that doesn't show up on the transcript, unless the barrister is, or sometimes the judge is adept enough to note, by the way, I note that people are laughing and have been laughing for the last 25 seconds. And I've actually been involved in a case where a finding of fact was reversed, where the judge had said this evidence was not credible, but didn't refer to the fact that everyone had laughed, including some of the legal representation on the other side, and therefore was approaching it sort of in breach of the rule of, the trial judge has got a palpable advantage over what they see, because that's one of the cases where it does matter. So one of the things that sort of comes out of that for me is how do you code for that on an appeal at an appellate level? How do you take into account, short of actually analysing the audio recordings and then also having to have the video to be able to capture demeanour, whether someone's remorseful or shows contrition or is obviously lying or appears to be obviously lying, because it can be really misleading. How do you account for that and those things that don't appear on the transcript? Long pauses between answering questions from when they're asked, which can often be used as an indication the person's making things up. I think that might be another area where it may be possible in future to bridge the gap, but at the moment I don't see a way of doing it. And finally, one other quick point is, from a practitioner's point of view, the speed at which a computer might make a decision is going to be too quick. We're going to finish a case and have an answer straight away. You're then going to have to go straight from having been in your 6-week trial to having your 28 days to prepare the appeal without having any time to recharge in the middle, and that's going to be impossible. Or at least very suboptimal. Perhaps that's what junior barristers were invented for.
Automated barristers.
Automated barristers. Yes. Anyway, sorry for the sort of relatively unstructured way in which I've approached it, but that was the way that it sort of occurred to me, trying to think it through logically. And if anyone wants to discuss any of the points that I've raised, I'm happy to talk about it afterwards. Thank you very much for your time.
Thank you. I think the two prior speakers have said most of what I was going to say, so I'll just sit down. No, seriously. First of all, thank you very much, Isabel, for this opportunity. Thank you for what, in my brief reading so far, and I haven't finished it yet, is an excellent issue of the journal. And all the editors, I haven't checked all the footnotes, but I'm sure they're great. Okay, so there's already been quite a bit said about lawyers and technology. And I think the main take-home for me is something which I, of course, already believed in, which is the real importance of a real deep sophistication across both domains. That we need lawyers who can understand these technologies from the inside out. And in fact, only this week, UNSW has approved a data science and decisions law degree, so there will hopefully in future be people who can really navigate these spaces very well. I really enjoyed Professor Sourdin's paper, so thank you very much, and the idea of AI judges. But of course, as an academic, I can't agree with everything, so I will also make some comments from my own perspective. And I suppose a little bit like the other speakers, and this is where I'm very conscious I'm going third, I have trouble with the idea of artificial intelligence, or AI, judges, as the entity here to be examined. And I have several problems with it. First of all, I think it provokes a kind of awe, right? When you hear the word artificial intelligence, again, Terminator. But you know, in any event, we sort of think of this as sort of something out there that is intelligent. It is a very positive word. And, you know, this tends to lead to solutions like, oh my gosh, you know, it's going to take over, like Arnold Schwarzenegger. Every lawyer needs to learn how to code. If we can't persuade the judges, we'll build them. We'll colonise that space. And I'm not sure that sort of awe type approach is very helpful. The other thing I think I have a problem with is the sort of anthropomorphism with this. So in other words, you know, what is intelligence? Intelligence is what every decent professional hopes their children will be. It is a positive thing, and it is very much associated with a human trait. We use the word intelligence, if you like, to measure particularly younger humans and evaluate them against each other and score them on various metrics and so forth. And so we then are taking something that's quite different and, if you like, trying to put it on the same scale. And I'll talk in a little bit about why I don't think that's right. And the third reason I don't like it is that it tends to give rise to this spectrum thinking. You are more or less, you are higher or lower on some kind of AI scale. In the article, the word is sort of sophisticated versus, you know, less sophisticated, different versions of AI, which tends to treat it as some kind of trajectory of the same thing. And so that's sort of, I suppose, the next thing I don't like about it. And the final thing is it's always about the ... We can talk about all the technologies we have at the moment, or the methods and techniques, but always the cool stuff is in, and then when it gets really so much better, it'll be able to do this, right? And that where that ... is going is always left a bit obscure. So what is artificial intelligence? And I'm going to kind of break it down a little bit. And I think it's very contextual. I think what we talked about as artificial intelligence when people wrote about it in the 1970s wouldn't be called artificial intelligence now. Now, when I first worked in the federal court, there weren't digital committees and other exciting things. I was a judge's associate there. It was very, very simple. They were well behind what the law firms had in terms of technology, and the processes were quite banal. I still remember when I used to sit in court, I had to fill in a form by hand because there was no possibility of technology in the courtroom, or certainly we weren't issued with the mechanisms to enable that. And so by hand you would fill out the form with all the orders and next court dates and so forth. And then you would take that form, and I'm not exaggerating, you would photocopy it 3 times. One of those copies was for Chambers, the original was for the file, and 2 of the copies went to the same person. One highlighted at the top and one highlighted at the bottom, which would remind that person to enter it into 2 different databases. Right? Now, the sort of, you know, when I heard they had a system, you know, where in court you could enter it once and that would automatically make everything else happen, that felt to me like artificial intelligence. Right? That was unbelievable and a revolution. But most of the time, and the article recognises this, when we talk about artificial intelligence, we mean machine learning. And machine learning is based on a particular logic. I read a machine learning textbook because I wanted to learn about what exactly this was. And it is a particular logic, and it is certainly not how intelligent children or otherwise do their reasoning. So to give you an example, what you might do is have a randomised process through which, if you like, data bits variables are randomly selected. You then basically generate randomly a whole bunch of very different decision trees. You run the data down those trees, perhaps in the hundreds of thousands, and then you allow the trees to vote on whatever the outcome of a case will be. That's random forests, very, very briefly. My children do not do this. This is not the same as intelligence. It might be able to yield some very useful insights or make some very interesting or even reliable predictions. But whatever it does, it is not how intelligent humans do their reasoning. Now, when I say it works on a particular logic, if we're thinking about this, the logic it works on is the underlying data, and this is a point that has already been made. A good example of the flaws in this is some of the critique of the compass system in the US. Now, for those who know it, sorry, I'm going to be boring for 5 seconds for those who don't. The compass system is a risk assessment tool that is used in criminal sentencing as well as bail and parole decisions, largely in the US, although as I found out recently, also apparently parts of Thailand and no doubt other places that I haven't yet worked out where it's happening. But essentially the idea is this: you take all the data you have, basically based on sort of questionnaires that are given to defendants. You then know from historic data how those people have performed in the system. Have they reoffended? Have they complied with bail? And so forth. You find correlations that allow you to say how dangerous or how compliant is this particular defendant based on how similar they are to other people who've been through the system who perform in various ways afterwards. And then you say, you know, and they lovely, because it's the US, of course, it's in colours, you know, there's a red, you know, bad, dangerous rating, and it goes down. And so you can then make allegedly sensible decisions. Now, this was originally introduced, of course, as a prison management system, who's going to medium security, high security prisons and so forth, but judges love it. The Council of State Chief Justices has sort of formally endorsed it. Everyone thinks it's wonderful, objective, scientific, of course, data-driven, evidence-based, you know, pick your word, this is it. Now, the first problem, and this isn't picked up by me, it was picked up by an organisation called ProPublica, is that, of course, it's racist. In other words, if you are African American, you are more likely to be a false positive. So that's just not more likely to be considered dangerous, because maybe they all are dangerous. Who knows? Trump said so anyway. But more likely to be flagged as dangerous when you are not. Right? So that is a clear problem. Now, the data science will go, we can correct for this. In fact, I've read another textbook which is all about how to, from a data science perspective, correct for this. But I don't think at the end of the day that's my only problem with this way of doing the reasoning. So another question in the questionnaire, and you can find the questionnaire online, the company hasn't published it, it's all black box, they refused to, the court didn't take evidence on the points, and the judges didn't even know the product they were talking about. In the case that decided it was actually allowed to be used in sentencing, which is Loomis for anyone who wants to look it up. But, sorry, going back a step, the point is that one of the questions on the questionnaire is, are your parents still together? And if not, if they're split up, how old were you when that happened? Now, that's an interesting example. This is not in the Anti-Discrimination Act, right? So having divorced parents or coming from a broken home is not an official ground on which you can complain about discrimination. Presumably they're asking it, and we don't have the full data set because they've evaluated that it correlates with dangerousness. I'm assuming that people from broken homes are more likely to become dangerous, but I don't actually have the data. But let's assume that's the case. Now, does that mean, if you think about this as being driven by the data, does that mean that if someone comes before the court, that the fact that their parents got divorced when they were 3 should be treated as relevant evidence in that person's sentencing, right? I think if you tried to introduce that, if you went into the criminal court, say in New South Wales, and said, I'm the prosecution, I have evidence that this person's parents got divorced when they were 3, and we all know about those kinds of people, that you would have, irrespective of the fact that it's not race or gender or anything else, you'd still have a problem. The kind of reasoning these tools use is foreign to the kinds of reasoning traditionally used in courtrooms. And it's not only in the context of criminal sentencing. There's a move to use this in the context of family law, albeit in the context of encouraging settlements. And again, that data is coming from historic data, right? Either it's coming from all the settlements or it's coming from the judgments. But either way, it is going to have all sorts of factors that have been considered in the past that due to ongoing social change may no longer be appropriate to consider now. So I think there's a problem with this kind of reasoning. I don't think it's well integrated with the way judges currently reason, and I think it would actually be a big shift to move towards it. And an example of this is, again, going back to that wonderful, really old AI and referring to an article I published in the UNSW Law Journal a few years ago. If we go back to the New South Wales Sentencing Information System, this was meant to be, and they didn't use the word data science then, they just called it statistics, but this was meant to help with sentencing and ensure that judges gave sentences that were consistent with sort of statistical trends on sentencing people in particular kinds of crimes and so forth, who have enough traits in common with past offenders. So it was meant to make sentencing consistent. And then you look at how the judges used it, and it was a glorified Ostley. You can think about the fact that, yes, it showed trends and yes, everything else. The judges weren't interested in the trend. They weren't interested in the mean. They went back to the cases, and you can read this in the judgments. They went back to the cases and said, well, yes, this person had this sentence, but on the other hand, there were these distinguishing factors in that case. And of course, in this case, and all the stuff you normally see in reasoning. They refused to reason statistically. It helped them find the judgments to which they could compare, like I said, the glorified Ostley, in order to be able to make comparisons along a traditional kind of path to say what the sentence in a particular case would be. And I tend to think, and I hope at least, that in Australia that would be the reaction of judges today. Now, the other problem with machine learning is the explainability problem. We've heard a little bit about this. So if judges are meant to explain their decisions, can machine learning deliver that? And I think the answer is, well, a lot of the current machine learning tools, random forests, are really bad at it. There are new XAI, which is one of the things, explainable AI, one of the things being developed by Data61 at the moment that says it can do it, but the logic is wrong. In other words, even if you came up with you could extract the logic from the algorithm, telling the defendant, well, you got a really long sentence because your parents divorced when you were 3, isn't going to be that helpful to them. So that's machine learning. Now, there are other kinds of automation and logics that sometimes do, sometimes don't come under the AI umbrella. Expert systems is another one. This is basically a tool with a pre-programmed logic. In other words, it will help you answer a question because the person who programmed it in already predicted you would ask it and has a decision tree of some kind that would get you to the right answer based on the answers you give in response to specific questions. And this can be great. I love expert systems. I teach them. So these are actually quite useful at a variety of functions, but it is only based on law that is either simple or at the absolute highest complicated. In other words, something like a sort of, you can have a lot of provisions, it can be a complicated logic, but it is a clear logic with clear pathways. The moment there is any kind of vagueness or uncertainty, the moment it is complex, you cannot really code it into an expert system. So it could be useful. It could absolutely be a co-bot sitting on the bench. So a judge who doesn't hear a lot of tax cases, for example, could use it to navigate through what is otherwise a very hard statute to read. But it has its limitations. And of course, we get to the ... So whenever I make these kinds of arguments, someone says, oh, you're just talking about what's there now in the future. We are building amazingly wonderful things, and they will be different, right? The kind that all the AI that I know about has a particular logic that you can dissect. I do not believe that will not be the case for whatever is built in the future. But I can't say now what the logic of those AIs will be. What I can say is that it's important to understand them before we start deploying them. So whether it's a brain simulator, pattern recognizer, text mimicry, it'll have a logic, and we need to understand that logic. And this is where humans and human intelligence differs from artificial intelligence and how it needs to be evaluated differently. I will never understand the logic of my teenage son, and that's kind of okay. But we do need to understand the logics here if we're going to deploy them effectively and appropriately. We need to understand the logic in order to evaluate its effectiveness at performing quite distinct and discrete, because I believe it will continue to be distinct and discrete judicial, or for that matter, any other task. Thank you.
Well, thank you very much. I do want to, in particular, thank the editors who, of course, helped me in relation to the article, and in particular thank Isabel for her support, but in fact the whole editorial team who has done a remarkable job. As people started talking, I actually travelled down from Newcastle today, where it was sunny when I left, and then I moved through gale weather, and I thought, yes, if only that dream of appearing by hologram was in fact a reality, which was in fact supposed to be the case. I think when I talked at something in Singapore about 15 years ago, it was indeed predicted that even at that point we would be appearing by hologram. So it's always difficult to predict the future and see what it looks like. I only wish it had arrived in relation to holograms at least. I'm very pleased to be part of the discussion today, and I'm very flattered that such eminent discussants have read my article. I must say I'm somewhat passionate about this topic, and I'm actually very pleased to provoke some awe and to generate a discussion around what I think are some significant ethical issues that judges and lawyers and litigants in fact face into the future in relation to Judge AI. And I call it Judge AI, and I suppose in thinking about Judge AI, I'm aware of many of the international developments where, in fact, AI is already being used in small claims. If you go onto YouTube, you'll see an example of the Suncorp small claims processing new approach, I suppose, that's being used now, which is founded on AI. But we're also aware of AI developments at the edges of the justice system, and some of them are more prominent than others. In my view, there are some really serious issues that are raised by these developments, and they include issues around where we draw the line and do we in fact divert small cases off to AI into the future, and where do we consider that AI should stop? Do we think about it in terms of monetary value or simple cases, or do we think about it in some other terms? This has been an area of great interest to me for a number of years. I actually was involved as a co-investigator on two Australian research councils in 2003 and 2008, where we actually developed branching technologies and reasonably sophisticated expert AI systems in the legal aid area and also in relation to family law. And already at that time, it was clear that you could develop some systems through branching expert systems, and it really didn't take that long to interview a number of experts and to think about what weight you would give to different, if you like, factors that were relevant to come up with an outcome. Again, there was always the issue of not actually having any reasoning that was attached to that, or although you could highlight issues, and you could in fact, I think, extrapolate out and take that to a decision-making piece. But the significant issues that relate to Judge AI, and I think they are significant, have been touched on in part by a number of our discussants this evening. And I think one of the first ones is, what sort of data set do you use? What sort of data do you interrogate to inform the AI system? And this is a really vexed, I think, question in the context of justice data. I did write a paper that came out, I think, earlier this year in the Rutgers Journal of Law and Technology, where I'd created a web crawler together with a team, and what we did was we did a crawl through all of the OSLI cases that have been decided in New South Wales and Victoria in the Supreme Courts of each of those states. And the web crawler process was quite interesting because I wanted to find out what are the characteristics of cases that are actually heard by judges in terms of civil cases. And predictably, only about 1.5% to 3% of cases were actually determined by a judge, so I think that's always an important factor to bear in mind. And of those cases, they were really quite aberrant. There were characteristics that those cases had which were unusual. If you looked at general cases, they often involved quite high levels of what I call task complexity, as well as high levels of behavioural complexity. So looking, if you like, at determined cases is very problematic if that's the data set that we're going to use. But I'm also really concerned that other data sets will be used, and I think some of the discussants have touched on that, although briefly. I was in China a few weeks ago, and of course AI is already being used there in relation to judicial determination, and it won't surprise you to hear that social credit scores will play a role in terms of sentencing and other matters in the context of China and those developments there. There are other questions as well. Will genetic information, for example, be relevant in the context of sentencing? Where do we draw the line? And this really, to my mind, are significant ethical issues that we need to consider in terms of, again, where we draw the line. There are significant second matters that I think are important in terms of creativity and innovation, in terms of the judicial role, and certainly the importance of dissenting in the judicial role and the role in which dissent plays, which I think the judge referred to. It's not just around the appellates, but it is in fact those law students and those barristers who will take those pearls of wisdom, and even if in fact you're downed at another level, will use those perhaps to generate something into the future. In that regard, it seems clear to me that Judge AI probably has a broader role to play in relation to civil countries rather than common law countries. And when I talk with judges from civil jurisdictions, I don't think that issue around creativity and innovation is acknowledged in the same sort of way. So I suspect that internationally we'll see different growths in terms of Judge AI into the future. A third concern, which I don't think was really touched on, is one which I refer to as executive overreach. And I do have concerns around the separation of powers, and it probably touches a little bit on Justice Burley's comments around who codes, and I think also your comments around who's actually responsible, who's creating, if you like, the system that sits behind courts. Now, most courts, and I've worked in courts on and off for years and had long stints in tribunals as a member at the AAT and elsewhere, quite clear to me that there are serious budgetary and other considerations that are at play. And a lot of the decisions that are made about what goes in and out of tribunals and courts are made at an executive level, and they're made without really much reference to courts. And so I have a real concern around executive overreach, a potential separations of power issue, as well as my fourth point, which is around budget and time pressures, and around how, in a sense, what we could adopt is something that we don't necessarily want either as a society nor in the context of our legal community. I am concerned there that what you may get is in fact a default template decision-making process that gradually morphs into something else, and judges who are under time pressures in different courts will simply move to accept that default judgment because after all it's come from the computer, it must be right, and won't in fact consider how they could be more creative or actually reflect very carefully on what's happened in a court process. Also, probably my fifth point, and there aren't many more, is just that a lot of the discussion that I hear around AI involves, and less so perhaps with judges, but it needs to be about judges, some fundamental misunderstandings about what judges do. And I think that's been remarked upon by some of the discussants tonight. I did a co-edited book in 2012 and another one this year, one called The Multitasking Judge and the other one called The Responsive Judge. And in relation to both of those works, I worked with judges and scholars internationally, and it's quite clear that judges do a lot more than just adjudicate. What they do in different courtrooms varies considerably. And there has been, I think, a significant move and a focus on, if you like, compassion and empathy shown by the judge and what a human being can bring into the room. In the context of therapeutic jurisprudence, it's obviously there, but in the context of the day-to-day interactions that people have with the courts, it's also important to recognise what humans bring into the room, their management context, the role of judges in terms of civil education, and the broader role of judges in the context of our society. The sixth point is that I will make, and it's my final one, is this question around too quick. A fascinating question. I reflect back, most people in the room won't remember the O.J. Simpson trial, but for those who do remember it, some of you may have studied it, I don't know, but that was of course a case where the jury returned a verdict very quickly, and then LA rioted in a sense, I think, because the jury was maybe too quick with the verdict. I mean, there were other reasons as well. But it was the speed of decision-making which was actually problematic. And it is this piece around we want to have a sense that the judge is grappling with what has come through and is torn by the arguments to be able to actually accept the judicial decision making. I do want to challenge that on one level because, of course, I have some digital natives that I've also given birth to, and they're fascinating young people. Because when I say to my son, you know, how would you feel if instead of waiting for 6 months to get a decision from a judge, you got something back in a week or so, and you didn't actually have to appear in court, and you didn't have to do anything else, or you know, maybe you did something on a video link or whatever it was. He seems to think that probably would be okay. Now, I'm just letting you know that because although many of you are law students and might think, oh God, I'm so offended by that notion that it would be okay, I think we need to be aware that for our digital natives, they may have different views around what a judge brings into the room and whether a judge should be involved at all levels of decision making, or whether there are some decisions that could be made by AI, supervised by a judge, or AI, perhaps even unsupervised. I am fascinated by this topic in part because I don't know whether any of you have heard, but the next judging of the gymnastics in the Olympics will in fact take place with an AI judge judging the Olympics. And in terms of creativity, I just wanted to respond quickly and note that, of course, we did have that very successful artwork sale recently of more than $400,000 created by an AI. So who quite knows where it will take it? The point, though, that I really wanted to make with the article that I'd written, and it certainly will also appear in other work that I have in the background at the moment, is that we need to have a conversation about this. We need to very carefully consider, I think, the ethical constraints, and judges need to be involved in this discussion, because oftentimes they haven't really been involved in discussions that we have that really focus on justice reform more generally. So that was my intention. I'm absolutely honoured that the discussants engaged with the paper, and very grateful to them for their very kind remarks. So thank you.